This is HOA backfired. The HOA made it personal, and I made it documented. I am standing in my side yard in Boulder, Colorado, holding a post hole digger, and Patricia is screaming at me about a fence post cap while the auger is still running 6 feet away. She is jabbing her finger at the cap like it personally insulted her family. "You are violating the design standards," she yells over the noise, and I have the authority to stop this work right now. I set the digger down and pull my phone out of my jacket pocket. I am a commercial photographer, so I always have a camera and extra batteries. I start recording. She does not care. She keeps yelling, "That post cap is not approved, the height is wrong, and you did not submit drawings." I am issuing a stop work order effective immediately. I moved to Boulder 2 years ago because I wanted mountain views and a decent place to work from home. The Rosewood Design Review Association seemed fine during the home tour. The rules packet was thick, but every HOA has rules. I did not realize that this subdivision operates on a simple principle. The moment you improve anything, the enforcement ramps up. I am saving for a down payment on a second property, a small investment rental, and the HOA is now trying to drain me with bogus fees before I can close the deal. 3 months ago, I decided to replace my rotting back fence. The old fence was falling apart, full of gaps, and the posts were sinking into the dirt. I pulled permits from the city, hired a licensed contractor, and submitted an application to the Rosewood Design Review Association with drawings, specifications, and photos. I followed every step in the covenant packet. 2 weeks later, I got a letter from Patricia, no last name on the signature, who is the Rules Interpretation Chair and claims she wrote the covenants herself. The letter said my application was incomplete and required additional engineering drawings and a land survey. I called the HOA management company. They said Patricia is not supposed to add requirements that are not in the covenants, but they also said they could not override her because she is the chair. I paid for a survey. I paid an engineer to stamp drawings for a residential fence. I resubmitted everything. Patricia sent another letter saying the fence height exceeded the maximum and the style was not compatible with the neighborhood character. I measured every fence on my street. Half of them were taller than mine, a quarter of them were chain link or wire mesh, which the covenants explicitly ban. None of those homeowners had fines. I took photos of all of them, logged the addresses, and built a spreadsheet. I sent the comparison photos to the management company and asked why I was being singled out. They said they would review it. Patricia sent me another letter the next day saying that prior violations do not excuse new violations and that I had 7 days to revise my application or withdraw it. I revised nothing. I started the fence work. My contractor showed up on a Monday morning with posts, panels, concrete, and an auger. We staked out the line, checked the survey twice, and started digging. By noon, Patricia was in my yard with a clipboard and her portable thermal printer. She printed a violation notice on the spot, no readable text, but I knew what it said, and stuck it on my front door. Then she came into the backyard and started yelling. That is when the auger was running and she screamed about the post cap. I recorded the whole thing. She said I was restricting HOA access by putting a temporary lock on my gate during work hours, which she claimed was a covenant violation. The gate was locked because we had equipment running, and I did not want random people wandering into an active construction zone. I told her that. She said, "Keep talking, I love adding notes." She told me I had 24 hours to submit a revised application with a corrected fence height, a new materials list, and a letter from my contractor accepting liability for HOA fines. If I did not comply, she would issue daily fines starting at $50 per day and escalating weekly. She also said the board would consider filing a lien if I did not stop work immediately. I asked her to show me the section of the covenants that gave her the authority to issue daily fines without a hearing. She said, "I do not need to show you anything, I wrote these rules." Then she said, "I can fine you daily until you give up and you cry." I did not say anything. I just kept recording. She printed another notice, slapped it on the fence panel, and walked away. I called my friend Aaron, who is a CPA and has dealt with HOA audits before. I sent him the notices, the letters, and the covenant packet. He called me back an hour later and said the numbers do not add up. He said Patricia was adding line items that were not in the approved fee schedule and that she was skipping the required hearing process. He also said the HOA was required to send violations by certified mail, not hand-delivered printouts. Aaron offered to come to the next board meeting and ask questions about the financials. I said yes. The board meeting was 2 weeks away, but I had a bigger problem. Patricia sent me a certified letter saying my cure deadline expired tonight and that daily fines would start tomorrow. The letter was dated 3 days earlier, but the postmark showed it was mailed yesterday. She was backdating notices to compress my response time. I took photos of the envelope, the letter, and the postmark. I sent everything to the management company and demanded an extension. They said they would ask the board. Patricia emailed me directly and said the board had denied my extension request and that the fines were active as of midnight. She copied the entire board and the management company on the email. I replied all and said I had documentation proving the notice was backdated and that I would be filing a complaint with the State Consumer Protection Office if the fines were not waived. She replied, "Keep talking. I love adding notes." The next morning, I woke up to a bright warning tag on my windshield. It was not a ticket. It was a tow notice from a private company, stamped with the HOA logo. The notice said my vehicle was parked in violation of the guest parking policy and would be towed in 24 hours if not moved. I was parked in my own driveway. I took photos of the tag, my driveway, and my house number. I called the towing company. The dispatcher said the HOA had called in the violation and that they were required to post a warning first. I asked for the name of the person who called it in. The dispatcher said Patricia Martinez. I asked if they had any documentation. The dispatcher said the HOA was supposed to send a violation log, but they had not received it yet. I asked if they could tow without the log. The dispatcher paused and said no, they needed proof of a valid violation and chain of custody documentation. I thanked him and hung up. I called Aaron and told him. He said that sounded like harassment and that I should document every contact. I was already doing that. Patricia escalated. She hired a photographer, not me, to take staged photos of my fence line from the sidewalk. The photos were shot at an angle that made my fence look closer to the property line than it actually was. She submitted the photos to the board with a report claiming I had violated the setback requirements and that my fence was encroaching on the HOA common area. I knew the photos were staged because I had my own survey and my own photos showing the fence was 2 feet inside my property line. The common area was nowhere near my fence. I sent my photos and the survey to the management company. They said they would review both sets of photos. Patricia sent another email saying the board had voted to reject my survey because it was not performed by an HOA-approved surveyor. I checked the covenants. There was no list of approved surveyors. I replied and asked for the list. She did not respond. Instead, she sent a letter threatening to file a lien packet with a bogus ledger and mystery line items. The ledger listed fines for unauthorized construction, non-compliance with design standards, refusal to submit required documents, obstruction of HOA access, and vehicle parking violations. The total was $4,000. None of the line items had dates, descriptions, or references to specific covenant sections. Aaron looked at the ledger and said it was garbage. He said any legitimate lien required an itemized breakdown with hearing dates and certified mail records. I did not have any of that because Patricia had never scheduled a hearing. I sent a formal demand to the management company asking for a hearing and copies of all certified mail records. The management company said they would forward my request to the board. Patricia replied and said the hearing was not required because I had waived my right to a hearing by continuing construction after receiving a stop work order. I checked the covenants again. There was no waiver provision. I replied and said I wanted a hearing. She ignored me. 2 days later, a tow truck showed up in front of my house. It had a distinctive amber strobe on the roof, the same truck I had seen twice before. The driver got out and walked up to my driveway. He said he had an order to tow my car. I asked to see the order. He showed me a printout with the HOA logo and Patricia Martinez listed as the contact. I showed him the photos of the tow warning tag and the dispatcher notes. He said he could not tow without a valid violation log and proof of chain of custody. I asked if he had received those documents. He said no. He said the HOA paperwork was missing and he needed me to prove chain of custody, which made no sense because I was not the one filing the tow order. He got back in his truck and left. I took photos of the truck, the license plate, and the amber strobe. I sent everything to Aaron. He said the tow attempts were a pattern and that I should file a police report for harassment. I filed the report that afternoon. The police officer who took the report said the HOA could not authorize a tow from private property without a valid violation and proper notice. He said if the tow company showed up again, I should call the police immediately. He also said the harassment complaint would be forwarded to the local prosecutor if the pattern continued. I thanked him and asked for a copy of the report. He gave me a case number. I sent the case number to the management company and told them the police were now involved. The management company replied and said they were suspending all enforcement actions pending a board review. Patricia sent me an email 1 hour later saying the board had overruled the management company and that enforcement would continue. She said the board had the authority to override the management company under the covenants. I checked the covenants. The board had no such authority. The management company was responsible for all enforcement actions. I replied and copied the relevant section. Patricia did not respond. The fence was finished 3 days later. My contractor did a final walkthrough, checked every post and panel, and confirmed everything was level, square, and inside the property line. He gave me a completion certificate and said the work met all city codes and the covenant specifications. I took final photos, updated my spreadsheet, and sent a completion notice to the HOA. Patricia replied immediately and said the fence was not approved and that I had 30 days to remove it or face a lien filing. I replied and said the fence met all covenant requirements and that I had documentation proving selective enforcement. She replied, "Keep talking, I love adding notes." I did not reply. I had been holding a trump card this whole time, and I did not correct her lie because I wanted her to commit to it in public. The trump card was a copy of the enforcement policy showing Patricia was skipping required steps on purpose. The policy was buried in the management company contract, not the covenants, and it required a formal hearing, certified mail notice, and a board vote before any fine could be assessed. Patricia had done none of that. She had been issuing fines and threats on her own authority, and the board had been rubber-stamping her decisions without knowing the policy. If you are enjoying this story, smash that like button and subscribe for more HOA nightmares. I did not reveal the enforcement policy yet. I wanted Patricia to escalate one more time so I could use it in front of witnesses. She did not disappoint. A week later, she showed up at my house with a chain and padlock. She said she was locking my gate to prevent further unauthorized construction. I said the construction was finished. She said the fence was not approved and that the gate was a safety hazard. I asked her to leave. She ignored me and started wrapping the chain around the gate. I pulled out my phone and started recording. She said, "You can record all you want. This gate is staying locked until you remove the fence." I said, "You do not have the authority to lock my gate." She said, "I have the authority to do whatever I want." A passerby holding up a phone with the screen turned away stopped on the sidewalk and started recording too. Patricia saw him and yelled, "This is private property, you need to leave." The passerby said, "I am on the public sidewalk, I can record whatever I want." Patricia turned red and started yelling at both of us. I stepped between Patricia and the gate. I said, "If you lock this gate, I will call the police and report vandalism and trespassing." She said, "You do not own this gate. The HOA has an easement for access and maintenance." I said, "Show me the easement." She said, "I do not need to show you anything. It is in the covenants." I said, "I have read the covenants 3 times. There is no access easement on this property." She paused. Then she said, "The easement is implied by the design standards." I said, "Implied easements do not exist in Colorado. You need a recorded document." She said nothing. The passerby on the sidewalk said, "Do you want me to call the cops?" I said, "Not yet, but thank you." Patricia dropped the chain and padlock on the ground and walked away. I picked them up and put them in my garage. I sent the video to Aaron and told him what happened. He said Patricia had just committed trespassing and attempted vandalism on camera, and that I should send the video to the management company and the police. I did both. The management company called me the next day. The rep said they were aware of the gate incident and that they had instructed Patricia to cease all direct contact with me. The rep also said the board was scheduling an emergency meeting to review the enforcement actions and that I would be notified of the date. I asked if I could attend. The rep said yes, and that I could bring documentation and witnesses. I said I would be there. The meeting was scheduled for the following Tuesday at 7 in the evening. I spent the weekend preparing. I printed copies of every email, every letter, every photo, every video, and every piece of documentation I had collected. I organized everything into a binder with tabs and a timeline. I also printed the enforcement policy from the management company contract and highlighted the sections Patricia had violated. Aaron agreed to come with me and ask questions about the financials. The passerby who recorded the gate incident gave me a copy of his video and said he would testify if needed. On Monday, the day before the meeting, I sent an email to every homeowner in the subdivision. The email included the comparison photo set showing multiple fences out of spec with 0 fines, the backdated notices, the bogus ledger, the staged photos, the tow attempts, and the gate incident video. I also included the enforcement policy and a summary of the violations Patricia had committed. I sent the email at 6 in the evening so people would see it before the meeting. By 9 that night, my inbox was full of replies. Half the homeowners said they had been targeted by Patricia for minor violations and that they were glad someone was finally pushing back. A quarter of the homeowners said they had no idea the enforcement policy existed and that they wanted to see it enforced fairly. The rest did not reply. Patricia sent me an email at 10 that night saying I had violated the HOA privacy policy by distributing homeowner information without consent. I replied and said I had not distributed any homeowner information. I had only shared my own documentation and publicly available HOA records. She did not reply. Tuesday evening, I arrived at the HOA meeting early. The meeting was held in a conference room at a local community center. Aaron was with me. The passerby who recorded the gate incident showed up and said he wanted to watch. The room filled up fast. I counted 30 homeowners, which was more than I had ever seen at an HOA meeting. The board sat at a table in the front. Patricia was at the far end wearing her purple jacket and blue bucket hat. She did not look at me. The board president, a retired accountant named Greg, called the meeting to order. He said the board had received multiple complaints about enforcement actions and that they were going to review the policies and procedures. He asked me to present my case. I stood up and walked to the front. I opened my binder and started with the timeline. I showed the application submissions, the rejection letters, the backdated notices, the bogus ledger, the tow attempts, and the gate incident video. I played the video on my phone and held it up so everyone could see. The room was silent. When the video finished, I pulled out the enforcement policy and read the relevant sections out loud. I said Patricia had issued fines without a hearing, without certified mail, and without a board vote, all of which violated the policy. I said the board had rubber-stamped her decisions without reviewing the documentation. I said the HOA owed me a formal apology, a waiver of all fines, and a written no-contact directive. Greg looked at Patricia. He said, "Is this true?" Patricia said, "I followed the procedures I was given." Greg said, "What procedures?" Patricia said, "The procedures I wrote when I became chair." Greg said, "Those procedures are not in the covenants or the management contract. Where did they come from?" Patricia said, "I have the authority to interpret the rules as needed." Greg said, "No, you do not. The management company handles enforcement, not the board." Patricia said, "The board has always deferred to my judgment." Greg said, "That does not make it legal." He turned to the management company rep who was sitting in the back. He said, "Is the enforcement policy she used valid?" The rep said, "No, the only valid enforcement policy is the one in the management contract, and it requires a hearing, certified mail, and a board vote." Greg asked Patricia if she had followed those steps. She said nothing. Greg asked again. Patricia said, "I did what I thought was necessary to protect the neighborhood." Greg said, "That is not an answer." Aaron stood up. He said, "I reviewed the HOA financials and I found multiple irregularities." He said the fee schedule Patricia used was not approved by the board and that several line items had no supporting documentation. He said the HOA had collected fines from at least 6 homeowners using the same invalid process and that the total amount was over $15,000. He said the HOA could be liable for refunds, penalties, and attorney fees if the homeowners filed complaints. Greg asked the management company rep if that was true. The rep said, "I cannot confirm without an audit, but based on what I am hearing, yes, there could be liability." Greg looked at Patricia. He said, "Did you issue fines without board approval?" Patricia said, "The board approved everything I did." Greg said, "Show me the meeting minutes." Patricia said, "The minutes are not detailed." Greg said, "Show me anyway." Patricia said, "I do not have them with me." Greg said, "Then we are done here." Greg said the board would suspend all enforcement actions pending a full audit. He said the management company would review every fine issued in the past 2 years and determine which ones were valid. He said any invalid fines would be refunded with interest. He also said the board would review Patricia's role as chair and determine whether she should continue. Patricia stood up and said, "I have been protecting this neighborhood for 5 years, and this is how you repay me." Greg said, "You violated the enforcement policy, you issued fines without board approval, and you harassed a homeowner on camera. I do not think you are protecting anyone." Patricia said, "I wrote the covenants. I know what they mean." Greg said, "You did not write the covenants. The developer did, and you do not have the authority to rewrite them." Patricia grabbed her bag and walked out. The room was silent. Greg looked at me and said, "I apologize on behalf of the board. This should not have happened." He said the board would issue a formal apology in writing and that all fines would be waived immediately. He also said the board would issue a no-contact directive prohibiting Patricia from contacting me directly. I said, "Thank you. I appreciate that." Aaron asked if the board would be filing a complaint with the state. Greg said, "We are discussing it, but yes, we are considering it." I sat down. The passerby who recorded the gate incident stood up and said, "I want to file a complaint about selective enforcement too." He said he had been fined for a lawn violation even though 5 other homes on his street had the same issue. Greg said, "Bring your documentation to the next meeting and we will review it." 3 other homeowners stood up and said the same thing. Greg said, "We are going to fix this, but we need time to do it right." The meeting ended at 9. I walked out with Aaron. He said, "You crushed her." I said, "I just wanted her to stop." He said, "She is not going to stop. She is going to fight this." I said, "Let her fight. I have everything documented." The next day, Patricia sent an email to the entire board saying I had defamed her at the meeting and that she was considering legal action. Greg replied and said her email was inappropriate and that she needed to direct all communication through the management company. Patricia replied and said she had the right to defend herself. Greg replied and said she had the right to remain silent. The board scheduled a special session for the following week to vote on Patricia's removal. I was not required to attend, but I wanted to be there. Aaron said he would come with me. The special session was on a Thursday evening. The room was packed again. Patricia was not there. Greg called the meeting to order and said the board had reviewed the enforcement policy violations and the audit results. He said the audit confirmed that Patricia had issued fines without board approval, without hearings, and without certified mail. He said the total amount of invalid fines was $18,000 across 9 homeowners. He said the HOA would be issuing refunds and that the management company would be implementing new oversight procedures to prevent future violations. He also said the board had voted to remove Patricia from her position as Rules Interpretation Chair, effective immediately. He said Patricia had been notified of the decision and that she had declined to attend the meeting. He said the board would be appointing a new chair and that all enforcement actions would be reviewed by the full board going forward. I left the meeting feeling relieved. Aaron said, "You won." I said, "Not yet." The HOA still owed me a formal apology and a written no-contact directive. Greg had promised both, but I had not received anything in writing. I sent an email to the management company the next day asking for a timeline. The rep replied and said the documents were being drafted and would be sent by the end of the week. Friday afternoon, I received a certified letter from the HOA. It was a formal apology signed by the board president. It said the board acknowledged that I had been subjected to improper enforcement actions, that all fines had been waived, and that the board regretted the stress and inconvenience I had experienced. It also included a no-contact directive prohibiting Patricia Martinez from initiating any contact with me, entering my property, or participating in any enforcement actions related to my property. The directive was signed by the board and the management company. I scanned the letter and saved it in 3 places. 2 weeks later, Patricia filed a lawsuit against me in small claims court. She claimed I had defamed her at the board meeting and that I had caused her emotional distress and reputational harm. She asked for $5,000 in damages. I called Aaron. He said, "This is ridiculous. You told the truth and you have documentation." I said, "I know, but I still have to respond." I filed a response denying all claims and attaching copies of the emails, letters, videos, and the enforcement policy. I also filed a counterclaim for harassment and abusive process. The court scheduled a hearing for 6 weeks later. I spent the next month preparing. I organized all my documentation, I printed timelines, I prepared witness statements, and I contacted the passerby who recorded the gate incident. He agreed to testify. Aaron agreed to testify about the financials. The management company rep agreed to provide a written statement confirming the enforcement policy violations. The hearing was on a Tuesday morning at the Boulder County Courthouse. I arrived early and met my attorney in the hallway right before the hearing. I had hired a local attorney who specialized in HOA disputes. Her name was Linda, and she had reviewed my documentation and said I had a strong case. Patricia arrived 10 minutes before the hearing. She was alone. She did not look at me. We were called into the courtroom. The judge was a middle-aged woman who looked tired. She asked Patricia to present her case. Patricia stood up and said I had publicly accused her of misconduct without evidence and that I had damaged her reputation in the community. She said she had served the HOA faithfully for 5 years and that I was a troublemaker who refused to follow the rules. The judge asked if she had any evidence of defamation. Patricia said, "He told lies about me at the board meeting." The judge said, "What lies?" Patricia said, "He said I issued fines without board approval." The judge said, "Did you issue fines without board approval?" Patricia paused. She said, "I issued fines based on my interpretation of the rules." The judge said, "That is not what I asked. Did the board approve the fines?" Patricia said, "The board trusted my judgment." The judge said, "That is still not an answer." Linda stood up. She said, "Your Honor, I have documentation showing that Patricia Martinez issued multiple fines without board approval, without hearings, and without certified mail, all in violation of the HOA enforcement policy." She submitted the enforcement policy, the emails, the letters, the videos, and the audit report. The judge reviewed the documents. She asked Patricia if she had followed the enforcement policy. Patricia said, "I followed the procedures I was trained to follow." The judge said, "Who trained you?" Patricia said, "I trained myself." The judge said, "So you created your own procedures and ignored the official policy." Patricia said, "I interpreted the covenants." The judge said, "Interpreting the covenants does not give you the authority to ignore the enforcement policy." She asked if Patricia had any documentation showing board approval for the fines. Patricia said, "The board approved everything at our meetings." The judge said, "Show me the minutes." Patricia said, "The minutes do not list every fine." The judge said, "Then you do not have proof of approval." Patricia said nothing. The judge asked me to present my case. Linda stood up and summarized the timeline. She said I had followed all the rules, submitted all required documents, and complied with all city codes. She said Patricia had targeted me with selective enforcement, backdated notices, bogus fines, tow attempts, and harassment. She said I had documented everything and that the HOA board had already removed Patricia from her position and waived all fines. She also said Patricia had filed this lawsuit in retaliation for my complaints. The judge asked if I had any witnesses. Linda said yes and called Aaron to the stand. Aaron testified about the audit and the invalid fines. He said the HOA had collected $18,000 in fines using an unapproved process and that the board had voted to issue refunds. The judge asked if Patricia had been involved in setting the fee schedule. Aaron said yes, Patricia had created the fee schedule without board approval. The judge asked Patricia if that was true. Patricia said, "I used my best judgment." The judge said, "Your best judgment is not a legal standard." Linda called the passerby who recorded the gate incident. He testified that he saw Patricia attempt to lock my gate and that she had yelled at both of us when we started recording. He said Patricia had claimed authority she did not have and that she had threatened to call the police on him even though he was standing on a public sidewalk. The judge asked Patricia if she had attempted to lock the gate. Patricia said, "The gate was a safety hazard." The judge said, "Did you have the authority to lock the gate?" Patricia said, "I had the authority to enforce the rules." The judge said, "That is not what I asked." Patricia said nothing. The judge asked if there were any other witnesses. Linda said, "I have a written statement from the HOA management company confirming the enforcement policy violations." She submitted the statement. The judge reviewed it. She asked Patricia if she had any rebuttal. Patricia said, "The management company does not understand the covenant history." The judge said, "The management company is responsible for enforcement, not you." The judge took a 10-minute recess. When she came back, she said she had reviewed all the documentation and testimony. She said Patricia had failed to prove defamation because everything I said at the board meeting was true and supported by documentation. She said my statements were protected as fair comment on a matter of public concern. She also said Patricia had violated the HOA enforcement policy, had issued fines without board approval, and had engaged in a pattern of harassment. She said my counterclaim for harassment and abuse of process was valid. She ruled in my favor on all counts. She dismissed Patricia's claims and awarded me $2,000 in damages for harassment and abuse of process. She also ordered Patricia to pay my attorney fees and court costs. Patricia stood up and said, "This is not fair. I was protecting the neighborhood." The judge said, "You were violating the rules you were supposed to enforce, and now you are paying the price." Patricia walked out. Linda said, "Congratulations, you won." I said, "Thank you for everything." She said, "The HOA will have to pay the judgment within 30 days, and if they do not, we can file a lien." I said, "I am not worried, the board will pay." She said, "They better, because the State Consumer Protection Office is watching." I asked what she meant. She said, "The state opened a case file after the board meeting, and they are investigating the HOA for unfair and deceptive practices." She said the investigation was triggered by the homeowner complaints and the audit results. She said if the state found violations, the HOA could face fines, sanctions, and mandatory oversight. I said, "Good, they deserve it." She said Patricia will probably be banned from serving on any HOA board in Colorado. I said, "Even better." I walked out of the courthouse. Aaron was waiting in the hallway. He said, "How did it go?" I said, "I won everything." He said, "Of course you did." We walked to the parking lot. I saw Patricia sitting in her car. She was on the phone. She did not look at me. Aaron said, "Do you think she will appeal?" I said, "She has nothing to appeal. She lost on the facts." He said, "Some people do not know when to quit." I said, "Let her try. I have everything documented." We got in my car and drove back to Boulder. On the way, Aaron said, "You should write this story down. People need to know what HOA boards can do if no one pushes back." I said, "Maybe I will." The HOA paid the judgment 2 weeks later. The check included the $2,000 in damages plus attorney fees and court costs. The total was $4,500. I deposited the check and sent a thank you email to Linda. She said, "You earned it." The board also sent me a final letter confirming that all fines had been waived, that the no-contact directive was permanent, and that Patricia Martinez had resigned from all HOA leadership roles effective immediately. The letter said the board was implementing new oversight procedures and that all enforcement actions would require a hearing and a board vote going forward. The letter also said the State Consumer Protection Office had issued a consent decree requiring the HOA to refund all invalid fines, adopt new transparency policies, and submit to annual audits for 3 years. The decree named Patricia Martinez as the primary violator and prohibited her from serving on any HOA board in Colorado for 5 years. I forwarded the letter to every homeowner in the subdivision. The responses were immediate. 6 homeowners said they had already filed refund requests and that the HOA had processed them without argument. 3 homeowners said they were planning to run for the board in the next election to make sure the reforms stuck. 1 homeowner said she was starting a neighborhood watch group to monitor HOA compliance. I said I would join. The fence stayed up. The city inspector came out 2 weeks after the hearing and confirmed that the fence met all codes. He gave me a final approval certificate. I framed it and hung it in my garage. Patricia never contacted me again. I saw her once at the grocery store. She turned and walked the other way. Aaron said, "You broke her." I said, "I just made her follow the rules." The HOA held elections 6 months later. 3 of the reform candidates won seats on the board. Greg stayed on as president. The new board voted to adopt the management company enforcement policy as the official HOA policy and to require board approval for all fines over $50. They also voted to publish all meeting minutes online and to allow homeowners to submit complaints anonymously. The changes were not perfect, but they were a start. I sold my investment property the following year and bought a second rental in a neighborhood with no HOA. Aaron said, "You learned your lesson." I said, "I learned that HOA boards only have the power you give them, and if you document everything, you can take it back." The state investigation concluded 18 months after the hearing. The Consumer Protection Office issued a public report finding that the Rosewood Design Review Association had engaged in unfair and deceptive practices by issuing fines without hearings, backdating notices, and using selective enforcement to target homeowners. The report named Patricia Martinez as the primary violator and recommended that the HOA implement mandatory board training, adopt transparency policies, and submit to annual audits. The report also recommended that Colorado update its HOA statutes to require independent audits and to create a state enforcement mechanism for covenant violations. The legislature passed a bill the following year. The bill required all HOAs to register with the state, to publish enforcement policies online, and to allow homeowners to file complaints with a state ombudsman. The bill also created penalties for board members who violated the enforcement policies. Patricia Martinez was listed in the bill summary as an example of why the law was needed. I got a letter from the state ombudsman office a year later asking if I would be willing to serve on an advisory committee for HOA reform. I said yes. The committee met quarterly and reviewed proposed regulations, homeowner complaints, and enforcement trends. I served for 2 years. The work was boring but important. Aaron said, "You turned a fence dispute into a statewide reform movement." I said, "I just wanted to build a fence." He said, "You got a fence and you got revenge." I said, "I got justice. Revenge would have been illegal." I still live in the same house. The fence is still standing. The HOA is still running, but it is running clean now. I see Greg at neighborhood events sometimes. He always says, "Thank you for keeping us honest." I say, "Thank you for listening." Patricia moved out of the subdivision 2 years ago. I heard she bought a condo in a building with no HOA. Aaron said that is ironic. I said that is karma. I check the state ombudsman website once a month. The complaint stats are down. The refund stats are up. The transparency requirements are working. The system is not perfect, but it is better. I did not set out to change the system. I just wanted to build a fence. But when the HOA came after me with bogus fines, backdated notices, and selective enforcement, I documented everything. I found the enforcement policy they were ignoring, and I used it to hold them accountable. The HOA lost in small claims and paid costs. Patricia was told to step down and she could not spin it. I got a fine waiver in writing with a firm no-contact directive. And the state opened a case that changed the rules for every HOA in Colorado. Thanks for watching, and I will catch you in the next one.